I was sitting in my home office on a Tuesday morning in Phoenix, Arizona, reviewing inspection reports when my doorbell rang 3 times in rapid succession. The aggressive nature of those rings immediately put me on edge. I walked to the front door of my modest 2-story house in the Sagebrush Hills community and opened it to find a woman in her late 40s with an asymmetrical blonde bob and oversized sunglasses perched on her head, clutching a leather-bound folder like it was the Holy Grail. "Are you Owen Matthews?" she demanded, her voice sharp enough to cut glass. "I am. Can I help you?" "I'm Patricia Summers, president of the Sagebrush Hills Homeowners Association. We need to discuss several urgent violations occurring at this property." She thrust a manila folder toward me without waiting for an invitation inside. I took the folder and opened it, scanning the contents. My eyebrows rose with each line I read. According to this document, I was being cited for maintaining an unsanitary outdoor kitchen area, improper food storage visible from the street, potential pest attraction due to compost bins, and creating a public health hazard with my weekend barbecue activities. "Mrs. Summers," I said slowly, "I think there's been a significant misunderstanding here." "There's no misunderstanding, Mr. Matthews. Multiple residents have complained about the smoke from your outdoor cooking area, and our HOA inspector noted several concerning health code violations during a routine neighborhood assessment last Thursday." I felt a smile tugging at the corner of my mouth, but I kept my expression neutral. "Your inspector noted health code violations?" "Yes. You're operating what appears to be a commercial-grade outdoor kitchen without proper permits or health department approval. The HOA bylaws clearly state that all structures must conform to local health and safety regulations." "I see. And you're prepared to pursue this matter?" Patricia's eyes narrowed. "If you don't remediate these violations within 7 days, the HOA will be forced to levy daily fines of $200. We may also pursue legal action to compel compliance." I nodded slowly, still holding the folder. "Mrs. Summers, before we go any further down this road, I should probably tell you what I do for a living." "Your occupation is irrelevant to HOA regulations, Mr. Matthews." "Actually, in this case, it's extremely relevant. I'm the director of the Maricopa County Health Department. I've held that position for 6 years. The color drained from Patricia's face so quickly I thought she might faint on my doorstep. Her mouth opened and closed twice before any sound came out. "You're what?" "I direct the department that oversees health code enforcement for the entire county, including this neighborhood. Every health inspector in this area reports to me. The outdoor kitchen you're concerned about was actually designed and built in consultation with our own commercial kitchen specialists to serve as a training example for residential food safety practices." Patricia's grip on her leather folder tightened until her knuckles went white. "That's—" I wasn't aware. Clearly. "Now, shall we discuss these alleged violations in detail? Because I'd be very interested to know who your HOA inspector is and what qualifications they have to assess health code compliance." She took a step back. "The board hired a private inspection company. They came highly recommended." "Name, excuse me. What's the name of this company?" Patricia fumbled with her phone, scrolling through emails. "Prestige Property Inspections. They're based in Scottsdale." I made a mental note of the name. "And did these inspectors actually enter my property, or did they conduct their assessment from the street?" "I believe they examined your property from publicly accessible areas." "So they trespassed, or they made determinations about health code compliance without actually inspecting the areas in question. Neither option speaks well for their professionalism or accuracy." Patricia's face had moved from pale to flushed. "Mr. Matthews, I'm simply trying to maintain community standards. By threatening the county's health department director with legal action based on a cursory inspection by unqualified individuals. Mrs. Summers, do you understand how many actual health code violations I investigate every single week? Restaurants with rodent infestations, food trucks operating without proper refrigeration, grocery stores selling expired meat. My outdoor kitchen has commercial-grade ventilation, NSF-certified food prep surfaces, and temperature-controlled storage that exceeds residential requirements. It's probably the most code-compliant cooking area in this entire neighborhood." She opened her mouth, but I wasn't finished. "Furthermore, the compost bins you mentioned are a county-approved green waste reduction initiative. I actually helped draft the guidelines for residential composting that minimize pest attraction. The materials I'm composting, the bin design, the location, the maintenance schedule, all of it exceeds recommended practices. The neighbors have complained about smells from weekend barbecues. Cooking food outdoors is not a health code violation, Mrs. Summers. It's a normal residential activity protected under property rights. Unless I'm operating a commercial food service business from my home, which I'm not, the HOA has no grounds to regulate my personal cooking activities." Patricia's expression shifted from embarrassment to defensiveness. "The HOA board has a responsibility to all residents. If your activities are creating a nuisance, then those residents can file formal complaints with the appropriate authorities, who will conduct actual investigations using qualified inspectors. What they cannot do is have the HOA hire a company with no health code expertise to make up violations and threaten me with fines. Mr. Matthews, I think we've gotten off on the wrong foot here." "You think?" I shook my head. "Mrs. Summers, I've been in public health for 15 years. I've worked in 3 different states and dealt with more regulatory frameworks than I can count. I moved into this community because it seemed quiet and well-maintained. I followed every rule in your CCRs. I submitted my architectural plans for the outdoor kitchen and got HOA approval before construction. Everything was done by the book. The board approved a patio cover, not a commercial kitchen. The plans clearly showed all appliances and equipment. If the board approved them without reading the specifications, that's not my problem. And it's still not a commercial kitchen, it's a high-end residential outdoor cooking area. There's a legal difference." Patricia's phone buzzed. She glanced at it and her expression tightened further. "I need to get to another appointment. The board will be reviewing this matter at our meeting next Tuesday evening. You're welcome to attend and present your perspective." "Oh, I'll be there. And I'll be bringing documentation of every permit, every approval, and every certification related to my property. I'll also be bringing information about the legal standards for health code enforcement and who is actually qualified to make such determinations." She turned to leave, then paused. "Mr. Matthews, the HOA is just trying to protect property values and community standards. I hope you can understand that. What I understand is that you threatened me with fines and legal action without doing basic due diligence about the facts. That's not protecting the community, Mrs. Summers. That's bullying a homeowner based on incomplete information." Patricia walked away without responding, her heels clicking sharply on my front walkway. I watched her climb into a white Mercedes SUV and drive off, probably faster than the 15-mile-per-hour speed limit posted throughout our neighborhood. I closed the door and returned to my office, but concentration on my original work was impossible. Instead, I pulled up the HOA's governing documents and began reading through them with the same careful attention I applied to health code regulations. If Patricia and her board wanted a fight, they'd picked the wrong person and definitely the wrong issue. My wife Sarah called around noon. She was a middle school teacher and usually ate lunch in her classroom while grading papers. "Hey, how's your day going?" she asked. "Interesting. The HOA president showed up this morning threatening us with fines." "What? For what?" I explained the situation, and Sarah's reaction was predictable. "They did not try to cite you for health code violations. That's insane. Completely insane, but also revealing. It suggests the board is either incompetent or deliberately targeting our property." "Why would they target us?" "We barely know anyone on the board. We've only lived here a year." "That's what I need to find out. Something doesn't add up." Sarah was quiet for a moment. "Do you think this is about the neighborhood barbecue we hosted last month?" I thought back to that event. We'd invited about 30 neighbors to celebrate the completion of the outdoor kitchen. It had been a nice evening, good food, friendly conversations. But there had been one awkward moment when Patricia and her husband showed up uninvited. "They weren't happy we didn't specifically invite them," I said slowly. "Because we didn't even know they lived in the neighborhood. We put flyers in mailboxes for the streets around us. How were we supposed to know she was HOA president?" Apparently, in Patricia's world, the HOA board gets special treatment. "This is ridiculous, Owen." "Agreed, but I'm going to handle it, don't worry." After hanging up with Sarah, I made several calls. First, to my deputy director, Marcus Chen, explaining the situation and asking him to pull any records on prestige property inspections. Then to our county legal counsel, inquiring about HOA enforcement authority regarding health codes. Finally, to a friend who worked in code enforcement for the city of Phoenix, asking about common HOA overreach issues. By late afternoon, I had my answers. Prestige Property Inspections was not licensed to conduct health inspections in Arizona. They were a general property management company that did HOA compliance checks, primarily for cosmetic issues like paint colors and lawn maintenance. They had no certified health inspectors on staff and no authority to assess health code compliance. More interesting, my friend in code enforcement told me that Sagebrush Hills HOA had a reputation for aggressive enforcement, and that several homeowners had filed complaints with the state about inappropriate fines and harassment. Nothing had risen to the level of legal action yet, but the HOA was on the radar of consumer protection advocates. I spent the weekend documenting everything about my outdoor kitchen. I photographed every surface, every appliance, every safety feature. I compiled all my permits, approval letters, and design specifications. I created a detailed presentation showing how the kitchen exceeded health code requirements and how the HOA had approved the construction. Sarah watched me work with a mixture of amusement and concern. "You're really going all in on this. If I don't, they'll target someone else. HOAs need oversight just like any other organization with authority over people." "You sound like you're preparing for a trial." "I'm preparing to educate a board that thinks they can throw around terms like health code violation without understanding what those words actually mean." Monday morning, I received an email from Patricia with the agenda for Tuesday's board meeting. My property violations were listed under old business between a discussion of holiday decoration policies and pool maintenance schedules. The dismissive placement irritated me more than it probably should have. I replied to the email. "Mrs. Summers, given that you're alleging violations that fall under County Health Department jurisdiction, I'll be bringing audio recording equipment to the meeting to ensure accurate documentation of all statements made by board members. Arizona is a one-party consent state, so this is simply a courtesy notification. Her response came within minutes. Recording board meetings requires advance approval per HOA bylaws. I checked the bylaws. There was indeed a provision about recording meetings, but it applied to official video recording for broadcast or publication. A homeowner recording for personal documentation was explicitly permitted. I replied. Reviewed Section 7.3 of the bylaws. Personal recordings by attending homeowners are permitted. See you tomorrow evening. No response. Tuesday at work was busy enough to distract me from the evening's confrontation. We had a situation with a restaurant chain that had failed 3 consecutive inspections at one of their locations, and I needed to decide whether to pursue permit suspension. We also had a potential foodborne illness outbreak linked to a catering company, which required coordinating with the state health department. By the time I left the office at 5:30, I was exhausted, but also focused. The HOA meeting started at 7, giving me just enough time to get home, change, and gather my materials. Sarah had offered to come with me, but I suggested she skip it. No point in both of us wasting an evening listening to pool maintenance discussions. You sure? I can provide moral support. I've got this. Besides, someone needs to be home in case the HOA president tries to issue another violation for unattended property. She laughed, but neither of us thought it was entirely impossible. The HOA meeting was held in the community center, a modest single-story building near the neighborhood entrance. When I arrived at 6:55, about a dozen other homeowners were already seated in folding chairs facing a long table where the board members sat. Patricia was in the center seat, flanked by 4 other middle-aged residents I didn't recognize. I took a seat in the back row and set up my phone to record, placing it conspicuously on the empty chair beside me. Patricia noticed, but didn't comment. The meeting started with standard business. Minutes from the last meeting were approved. The treasurer reported that the HOA had a healthy reserve fund. There was a lengthy discussion about whether to allow inflatable Christmas decorations that exceeded 8 feet in height. The pool maintenance update revealed that one of the pumps needed replacing at a cost of $6,000. Finally, Patricia cleared her throat and looked at her agenda. Next item. Enforcement action regarding property at 2847 Desert Bloom Lane. That was my address. Mr. Matthews, you're here. Would you like to address the board? I stood and gathered my materials. Yes, thank you. I'd like to start by providing some context about my background and qualifications to speak on this issue. I walked to the front of the room and handed each board member a packet I'd prepared. It included my resume, certifications, and a summary of Arizona Health Code regulations. As you'll see, I'm the director of the Maricopa County Health Department. I oversee all health code enforcement for this county, including this neighborhood. I have a master's degree in public health and 15 years of experience in regulatory compliance. One of the board members, a man in his 60s with silver hair, looked up from the packet. We're aware of your position, Mr. Matthews. Patricia informed us after her visit to your home. Good. Then you'll understand why I'm concerned about the allegations in this violation notice. I held up the folder Patricia had given me. This document claims multiple health code violations at my property. However, the inspection was conducted by a company with no health code expertise and no licensed health inspectors on staff. Patricia interjected. Prestige Property Inspections is a qualified firm that conducts assessments for HOAs throughout the valley. They conduct general property inspections, Mrs. Summers. They are not qualified or licensed to assess health code compliance. In fact, misrepresenting oneself as a health inspector is a violation of Arizona state law. That got the board's attention. The silver-haired man leaned forward. Are you saying the company we hired broke the law? I'm saying they exceeded their authority and expertise. Whether it rises to the level of criminal misrepresentation would depend on what they actually told you and how they characterized their findings. Patricia's face reddened. They provided a professional assessment of potential violations. Based on what qualifications? Did any of their inspectors actually examine my outdoor kitchen? Did they review my permits or design specifications? Did they have the technical knowledge to assess commercial-grade ventilation systems or NSF-certified equipment? Silence. I continued. I've brought extensive documentation showing that my outdoor kitchen was built with HOA approval, meets all local building codes, and exceeds health department standards for residential food preparation areas. I'd like to walk the board through this documentation so we can resolve this misunderstanding. For the next 20 minutes, I presented my case. I showed the original architectural plans submitted to the HOA, complete with the approval stamp. I showed building permits from the county. I showed photos of every major component of the kitchen, explaining how each element met or exceeded code requirements. I explained the difference between residential and commercial food service, and why my outdoor kitchen clearly fell into the residential category despite its high-end equipment. The board members looked increasingly uncomfortable. The silver-haired man kept glancing at Patricia, who sat rigid in her chair, arms crossed. When I finished, I asked, "Does anyone have questions about anything I've presented?" A woman at the end of the table raised her hand tentatively. "Mr. Matthews, your outdoor kitchen is quite elaborate. Some neighbors have expressed concern that it might be used for catering or other commercial purposes. Has anyone observed commercial activity at my property? Food trucks, commercial vehicles, people coming and going at odd hours? Anything that would actually indicate a business operation?" "Well, no, but my wife and I cook at home. We enjoy entertaining friends and neighbors. That's not a commercial activity. If the HOA has evidence of actual commercial food service being conducted from my property, I'd like to see it." Patricia finally spoke. "The issue isn't just the kitchen, Mr. Matthews. It's the cumulative impact of your activities on the neighborhood. The smoke, the noise, the traffic from your gatherings. I've hosted exactly 2 gatherings since moving here. One was the neighborhood barbecue I mentioned, which lasted from 5 to 9 on a Saturday evening. The other was a small dinner party with 6 guests. Neither event violated any HOA rules about gatherings, noise, or guest parking. Multiple neighbors have complained." "Then I'd like to see those complaints. Written complaints with specific dates and allegations. Because if neighbors have concerns about my property, they have the right to express those concerns through proper channels. What they don't have the right to do is make up health code violations." The silver-haired man cleared his throat. "I think what we're discovering here is that there may have been some miscommunication about the nature of the issues at Mr. Matthews' property. Perhaps we should table this matter and conduct a more thorough review." Patricia shot him a sharp look. "Robert, we have documented violations. We have a report from a company that apparently wasn't qualified to make the assessments in their report. That's a problem, Patricia." Robert turned to me. "Mr. Matthews, speaking personally, I apologize for this confusion. It seems the board may have acted on incomplete information." "I appreciate that, Robert, but I'm concerned this isn't just about my property. How many other homeowners have been cited for violations based on questionable inspections? Patricia stood abruptly. This board acts in good faith to enforce our community standards. If you're implying otherwise, I'm stating a fact. You hired an unqualified company to conduct health code assessments. You issued violation notices without verifying the facts. You threatened fines and legal action against a homeowner who was in full compliance with all actual regulations. That's not good faith, Mrs. Summers. That's negligent governance at best. Another board member, a younger woman with dark hair, spoke up. Mr. Matthews has a point. We should review our enforcement procedures to ensure we're not overstepping our authority. Jennifer, this is not the time, Patricia began. Actually, it is exactly the time, Jennifer replied. We've had increasing complaints from homeowners about aggressive enforcement. Maybe we need to take a step back and assess how we're operating. The meeting devolved into an argument among board members about enforcement policies, with Patricia defending the current approach and Robert and Jennifer pushing for reforms. The other two board members stayed silent, looking like they wanted to be anywhere else. I let them argue for a few minutes, then raised my hand. Excuse me, I'd like to make a formal motion. Patricia glared at me. Homeowners can't make motions at board meetings. Actually, Section 7.5 of the bylaws allows homeowners to make motions related to enforcement actions against their property. I move that the violation notice issued to 2847 Desert Bloom Lane be rescinded in its entirety, with a formal acknowledgement that no violations existed. Robert nodded. I second that motion. We need to vote on this in closed session, Patricia protested. No, Jennifer said firmly. Enforcement actions are recorded in open session per our bylaws. This vote needs to happen now. Patricia looked trapped. Fine. All in favor of rescinding the violation notice. Robert, Jennifer, and one of the silent board members raised their hands. Patricia and the remaining member didn't move. Motion passes 3-2, Robert announced. The violation notice is rescinded. I nodded. Thank you. I'd also like the minutes to reflect that Prestige Property Inspections is not qualified to conduct health code assessments, and any future reports from that company should be reviewed by qualified professionals before enforcement action is taken. So noted, Robert said, writing on his legal pad. Patricia gathered her papers with sharp, angry movements. If there's no further business, I motion to adjourn. Seconded, said one of the silent members, probably desperate to leave. The meeting ended and homeowners began filing out. Robert approached me as I packed my materials. Mr. Matthews, again, I apologize for this situation. Some of us on the board have been concerned about the direction of our enforcement policies. This incident highlights problems we need to address. I appreciate your integrity, Robert. For what it's worth, I think most HOAs serve a legitimate purpose, but they need appropriate oversight and accountability. Agreed. I hope this hasn't soured you on the neighborhood. Not the neighborhood, just the current board leadership. Robert lowered his voice. Between you and me, there's going to be a board election in 6 months. Several of us are hoping for some fresh perspectives. I understood the subtext. Patricia's days as HOA president might be numbered. As I walked to my car, Jennifer caught up with me. Mr. Matthews, can I ask you something? Of course. Would you be willing to serve on a committee to review our enforcement procedures? We need someone with actual regulatory expertise to help us develop reasonable policies. I thought about it. Getting involved with HOA politics was the last thing I wanted, but if it prevented other homeowners from facing similar harassment, maybe it was worth the time. Let me think about it. Can you send me an email with more details about what the committee would involve? Absolutely. Thank you for standing up to Patricia tonight. She's been running this board like her personal fiefdom for 3 years, and it's time for that to end." I drove home feeling vindicated but also somewhat troubled. The HOA issue was resolved for my property, but the broader problems with the board's approach remained. Patricia had shown no remorse, no acknowledgement that she'd been wrong. People like that didn't learn from their mistakes. They just got angrier and looked for new targets. Sarah was watching a cooking show when I got home. "How'd it go?" Violation rescinded, board members arguing with each other, HOA president humiliated in front of homeowners. "Pretty good outcome." "So it's over?" "For us, yes. But I have a feeling there's going to be ongoing drama with that board." I was correct. Over the next week, I heard through neighborhood gossip that Patricia had been pressuring Robert and Jennifer to resign from the board. She'd also been making calls to other homeowners, trying to rally support for stricter enforcement policies. Then, 8 days after the board meeting, I received an email from Maricopa County Legal Counsel. Patricia Summers had filed a formal complaint against me with the County Ethics Board, alleging that I had used my position as Health Department Director to intimidate the HOA and abuse my authority. I read the complaint twice, fury building with each paragraph. She was actually claiming that I'd threatened to use county resources to retaliate against the HOA if they didn't rescind the violation notice. She alleged that I'd improperly used my title and position to create a hostile environment for board members. She even suggested that my outdoor kitchen might actually be in violation of codes, but that inspectors were afraid to cite me because of my position. It was complete fiction. Every word. But it was also a serious accusation that required a formal response. I immediately contacted our county legal counsel and provided recordings of my conversation with Patricia at my home and the entire board meeting. I also documented the timeline of events, showing clearly that I had done nothing but defend my property against false allegations using facts and evidence. The county ethics investigator, a serious woman named Deanna Carlson, reviewed everything within 3 days. She called me into her office on a Friday afternoon. "Owen, this complaint is completely without merit. You didn't use county resources, you didn't threaten anyone, and you didn't abuse your authority. You defended your property using your personal expertise and public information. That's not an ethics violation. So the complaint is dismissed. The complaint is dismissed, and I'm adding a note to the file that the complaint appears to have been filed in bad faith as retaliation for a legitimate dispute. If Miss Summers files any additional complaints against you, we'll be looking at them with extreme skepticism. Thank you, Deanna. Off the record. This woman sounds like a nightmare. Have you considered filing a defamation claim against her?" I hadn't, but the idea had merit. "Would the county support that? If you filed in your personal capacity, not as Health Department Director, I don't see why not. These allegations could harm your professional reputation. That's textbook defamation." I thanked Deanna and left her office, mind racing. A defamation suit would be expensive and time-consuming, but it would also send a clear message that Patricia couldn't weaponize false accusations without consequences. I discussed it with Sarah that evening. She was less enthusiastic about prolonged legal action. Do we really want to get more entangled with this woman? The HOA issue is resolved. Let it go. It's not about the HOA anymore. She filed false ethics charges against me. She's attacking my professional reputation. That's different from an HOA dispute. I know you're angry. I'm not just angry, Sarah. I'm concerned about the precedent. If she can file baseless ethics complaints without consequences, what stops her from doing it to other people, other county employees, anyone who crosses her? Sarah sighed. You're going to do what you think is right. You always do. Just promise me you'll think carefully about whether this is a battle worth fighting. I promised, and I did think about it. For 3 days, I weighed the costs and benefits of pursuing legal action against Patricia. Then something happened that made the decision for me. I received a call at work from a man named David Foster. He lived in Sagebrush Hills, 4 streets away from me, and he'd heard about my confrontation with the HOA board through neighborhood gossip. Mr. Matthews, I'm calling because I'm facing a similar situation with the HOA. They've cited me for having a storage shed that allegedly violates setback requirements. But I built the shed 5 years ago with HOA approval, and it's in the exact location shown on the approved plans. Did they say why they're suddenly citing you now? I voted against Patricia in the last board election. I supported her opponent. Ever since then, she's been looking for ways to find me. The shed is just the latest excuse. I felt my jaw tighten. Have other homeowners reported similar issues? At least 3 that I know of. All of them had some conflict with Patricia or voted against her candidates. It's a pattern of retaliation. David, would you be willing to document your experience in writing? Dates, correspondence, specific events? Absolutely. Are you planning to do something about this? I'm considering it. If we can show a pattern of abuse of authority, that changes things significantly. Over the next week, I connected with David and 4 other homeowners who had experienced what they believed to be retaliatory enforcement actions by the HOA under Patricia's leadership. The stories were remarkably consistent. Each homeowner had either opposed Patricia politically or complained about HOA policies. Each had subsequently been cited for violations that were either fabricated or represented selective enforcement of rules that many other homeowners violated without consequence. I compiled all of this information into a detailed report. Then, I scheduled a meeting with the county's Consumer Protection Division and the state's HOA Ombudsman Office. Both agencies had authority to investigate HOA misconduct. The meeting took place on a Wednesday morning at the County Administration Building. I presented the evidence to representatives from both agencies, including my own experience, the experiences of the 5 other homeowners, and documentation showing the pattern of selective enforcement. The state ombudsman, a sharp-eyed man named Richard Liu, listened carefully and took detailed notes. Mr. Matthews, this is concerning. HOAs have broad authority, but that authority must be exercised in good faith and applied consistently. What you're describing sounds like potential abuse of fiduciary duty. That's my assessment. These homeowners are paying HOA fees for community governance, not to fund a personal vendetta operation. Do you have any evidence that the HOA president personally benefited from these enforcement actions? Financial kickbacks from contractors, that sort of thing? I hadn't considered that angle. Not that I'm aware of. I can look into it. The county consumer protection representative, a younger woman named Lisa Martinez, spoke up. Even without financial benefit, this kind of selective enforcement may violate Arizona's HOA statutes. We should open a formal investigation. Richard nodded. I agree. We'll send an investigation notice to the Sagebrush Hills HOA board and request their enforcement records for the past 3 years. We'll compare citation patterns to board election results and complaint histories. How long does this process typically take? I asked. 4 to 6 months for a thorough investigation. Could be longer if the HOA doesn't cooperate. I thanked them both and left feeling like progress was being made. Patricia had gone from harassing individual homeowners to facing potential state sanctions. But I knew the investigation would make her even more aggressive in the short term. Cornered people often lash out. I was right. 2 weeks after the investigation notice was delivered to the HOA board, I received a certified letter informing me that the HOA was pursuing legal action against me for creating a hostile environment for board members and interfering with legitimate HOA governance. The letter was from a law firm in Scottsdale that specialized in HOA representation. It was filled with legal jargon but light on specific allegations. Mostly, it seemed designed to intimidate me into backing down from the state investigation. I forwarded the letter to Richard Liu at the Ombudsman's office. He called me within an hour. "Owen, this is retaliation, clear as day. I'm adding this to our investigation file, and I'm contacting the attorney who sent this letter to inform them that their client is now under investigation for HOA misconduct. That usually cools things down pretty quickly. Will it stop the lawsuit?" Can't guarantee that, but most attorneys don't want to pursue frivolous cases against state investigation witnesses. It looks bad and opens them up to sanctions. Richard was right. 3 days later, I received another letter from the same law firm, this time stating that after further review of the matter, they had decided not to pursue litigation at this time. The letter emphasized that this wasn't an admission of wrongdoing by the HOA, just a business decision. I kept that letter in a file marked Patricia's Greatest Hits, along with all the other documentation of her behavior. Sarah found the file label amusing but concerning. "You're really invested in this now. Someone has to be." These HOA board members wield significant power over people's homes and lives. They need accountability. The state investigation proceeded through the spring. Richard's office subpoenaed HOA records and interviewed board members and homeowners. The process was thorough and professional. Richard kept me updated on general progress, but couldn't share specific findings during the active investigation. Meanwhile, life in the neighborhood became noticeably tense. Patricia had apparently told her allies that I was trying to destroy the HOA, which wasn't true but made for dramatic gossip. Some neighbors avoided me. Others sought me out to share their own HOA horror stories. The board election that Robert had mentioned came in June. Patricia ran for re-election as president, facing a challenge from a retired accountant named Michael Torres, who campaigned on transparency and fair enforcement. The election was surprisingly heated for an HOA contest, with dueling candidate forums and campaign flyers in everyone's mailboxes. I didn't publicly endorse either candidate, but I did vote for Michael. So did Sarah. So did most of the homeowners who'd been targeted by Patricia's enforcement regime. Michael won by a nearly 2-to-1 margin. Patricia was voted off the board entirely, replaced by a newcomer who'd never served before. Robert remained on the board and was elected vice president. Jennifer became treasurer. The day after the election results were announced, Patricia's house went up for sale. She was leaving the neighborhood. But the state investigation wasn't finished. In August, 7 months after I'd first met with Richard Liu, the Ombudsman's office released its findings. The report concluded that the Sagebrush Hills HOA, under Patricia Summers' leadership, had engaged in selective enforcement of community rules, failed to apply standards consistently across all homeowners, and created an environment where board authority was used for personal retaliation rather than legitimate community governance. The report stopped short of calling Patricia's actions criminal, but it mandated significant reforms for the HOA, including new enforcement procedures, required training for board members, and oversight by an independent compliance monitor for 2 years. More significantly, The report recommended that affected homeowners consider pursuing civil claims for damages resulting from inappropriate enforcement actions. That recommendation gave legal cover to anyone who wanted to sue the HOA or Patricia personally. David Foster, the homeowner who'd first contacted me about his storage shed, organized a group of 5 homeowners to file a joint lawsuit against Patricia for abuse of authority and intentional infliction of emotional distress. I wasn't part of that lawsuit, but I provided a detailed affidavit describing my experiences and the pattern I'd observed. The lawsuit was filed in Maricopa County Superior Court in September. Patricia's attorney tried to get it dismissed, arguing that board members had immunity for actions taken in their official capacity. The judge denied the motion to dismiss, finding that the alleged pattern of personal retaliation fell outside the scope of legitimate board authority. I thought that might be the end of my involvement, but in October, I received a subpoena to testify at a deposition. Patricia's attorney wanted to question me about my interactions with the HOA and the state investigation. The deposition took place in a conference room at the plaintiff's attorney's office in downtown Phoenix. Patricia was there with her lawyer, a slick-looking man in an expensive suit. The plaintiffs were represented by a woman named Rachel Goldstein who specialized in HOA disputes. Patricia wouldn't look at me as I was sworn in. She sat with her arms crossed, staring at the table. Her attorney, whose name was Kenneth Barker, started with basic questions about my background and position. Then he moved to the real issues. "Mr. Matthews, isn't it true that you used your position as health department director to intimidate my client?" "No. I defended my property against false allegations using facts and evidence. But you specifically mentioned your title and position during your meeting with Mrs. Summers. After she threatened me with fines for alleged health code violations. My position was directly relevant to the discussion because she was making accusations about an area of law I literally oversee. Did you ever threaten to use county resources against the HOA? Never. Not once. I have recordings of every conversation. You're welcome to review them." Kenneth looked frustrated. "You filed a complaint with the state ombudsman's office. As is my right as a homeowner and a concerned citizen, filing a legitimate complaint isn't retaliation or abuse of authority. You encouraged other homeowners to make complaints against my client. I informed other homeowners about their rights under Arizona law. That's called being a good neighbor and a responsible citizen." The deposition continued for 2 more hours. Kenneth tried various angles to portray me as the aggressor or to suggest I'd abused my position, but the facts didn't support his narrative. Every decision I'd made was documented and defensible. When it was Rachel's turn to question me, she focused on establishing the timeline of events and Patricia's specific actions and statements. My testimony supported the plaintiff's claims that Patricia had engaged in a pattern of retaliatory enforcement. After the deposition, Rachel pulled me aside. "Thank you, Mr. Matthews. Your testimony was very helpful. Between you and me, I think this case settles within the next month. The facts are terrible for the defense." She was right. In early November, the parties reached a confidential settlement. I wasn't privy to the terms, but David Foster told me the homeowners were satisfied with the outcome. More importantly, Patricia agreed not to seek any position of authority in any HOA in the future as part of the settlement. By December, life in Sagebrush Hills had largely returned to normal. Michael Torres proved to be a competent and fair HOA president. The board focused on actual community issues like maintaining common areas and organizing neighborhood events. Enforcement actions were rare, and when they occurred, were based on clear violations applied consistently across all homeowners. Sarah and I hosted a Christmas party in mid-December, using the outdoor kitchen that had sparked the entire conflict. We invited about 40 neighbors, including Michael, Robert, Jennifer, and David Foster. It was a pleasant evening with good food and genuine community connection. As I was grilling steaks on my commercial-grade but definitely residential outdoor cooking equipment, Robert approached with a beer in hand. "Owen, I wanted to thank you again for what you did. A lot of us were frustrated with Patricia's leadership, but didn't know how to push back effectively. You showed us that HOA boards aren't untouchable." "I just defended my property, Robert. You and Jennifer did the hard work of reforming the board from within. Still, the neighborhood is better because you stood up. That matters." I appreciated his words, but I was also ready to leave the whole experience behind. I'd never wanted to be the neighborhood hero or HOA reform advocate. I just wanted to cook in my outdoor kitchen without being harassed. A few weeks later, I was at a county budget meeting when I ran into Deanna Carlson, the ethics investigator who dismissed Patricia's complaint against me. "Owen, I heard about the state investigation and the lawsuit. Sounds like your HOA situation got resolved." "Eventually. It was a longer process than I would have liked. That ethics complaint she filed against you really bothered me. I see a lot of frivolous complaints, but that one was particularly malicious. I appreciate you dismissing it quickly. Actually, I wanted to tell you something. After I closed your case, I referred Patricia Summers to the county attorney's office for filing a false report. It's a misdemeanor under Arizona law to knowingly file false allegations with a government agency." I was surprised. "I didn't know you did that." "The county attorney reviewed it and decided not to prosecute. Not enough public interest, they said, but it's in her record now. If she ever files another false complaint against anyone, that prior referral will be relevant. So there were some consequences. Some. Not as much as there should have been, in my opinion, but something." As winter turned to spring, I reflected on the entire saga. It had consumed nearly a year of my life, created stress for my family, and exposed me to a side of community governance I'd never wanted to see. But it had also revealed something important about systems of power and accountability. HOAs operate with significant authority but minimal oversight. Board members can make decisions that dramatically impact homeowners' lives and property values, often with no expertise and little accountability. Patricia Summers had exploited that structure to pursue personal vendettas and enforce arbitrary standards. She'd gotten away with it for years because individual homeowners felt powerless to challenge the board. My situation was unusual because I had expertise that directly contradicted the HOA's allegations, and I had the resources and knowledge to fight back effectively. But most homeowners don't have those advantages. They face a choice between accepting unfair treatment or spending thousands of dollars on attorneys to fight HOA actions that might only result in hundreds of dollars in fines. The system was broken, or at least badly flawed. The state investigation and mandatory reforms for Sagebrush Hills HOA were steps in the right direction. But they only happened because I'd escalated the issue and had the credibility to be taken seriously by state agencies. I thought about writing an op-ed for the Phoenix newspaper about HOA reform, but Sarah talked me out of it. "You've done enough. Let someone else carry that torch for a while." She was right. I'd made my point, protected my property, and helped several neighbors in the process. That was enough. In April, Patricia's house finally sold. A young couple with 2 kids moved in. They introduced themselves to neighbors, including us, and seemed friendly and normal. They had no idea about the drama that had surrounded the previous owners. I didn't tell them. It wasn't relevant to their experience, and they deserved a fresh start in the neighborhood. By summer, the entire conflict felt like ancient history. The outdoor kitchen continued to function perfectly. We hosted occasional gatherings for friends and neighbors. The HOA board operated efficiently and fairly under Michael's leadership. Life was good. One evening in late July, I was preparing dinner when my phone rang. It was Richard Liu from the state ombudsman's office. "Owen, I wanted to give you an update. You remember the monitoring period we imposed on Sagebrush Hills HOA? Of course. 2 years of oversight. The independent monitor filed her first report. The board is in full compliance with all required reforms. Enforcement actions are documented properly, applied consistently, and based on legitimate violations. It's actually one of the better-run HOAs in the state now." "That's good to hear. I wanted you to know because your complaint started all of this. The reforms we mandated for your HOA are now being used as a model for other communities. You helped change HOA governance in Arizona." After hanging up, I walked outside to the outdoor kitchen and fired up the grill. Sarah joined me with glasses of wine. "Was that about the HOA stuff?" she asked. "Yeah. Apparently, we're a model for HOA reform now," she laughed. "All because Patricia couldn't handle that we didn't invite her to a barbecue, and because she thought she could threaten the health department director with health code violations." Never threaten someone with violations in their own field of expertise. That should be a life rule. We clinked glasses and watched the sun set over the Arizona desert. The outdoor kitchen where everything had started gleamed in the fading light, all stainless steel and professional equipment. It was exactly what I'd wanted when I designed it, a place to cook good food for people I cared about. Patricia had tried to turn it into evidence of wrongdoing, a violation of community standards, a threat to neighborhood order. She'd failed because the facts were on my side, and because I'd had the knowledge and resources to fight back. But the experience had taught me something valuable about how power works in everyday life. HOA boards, regulatory agencies, professional organizations, all of them exercise authority that can dramatically impact people's lives. When that authority is misused, someone needs to push back. Someone needs to stand up and say the facts don't support your allegations. Your enforcement is inconsistent. Your decisions are based on personal animus rather than legitimate community interests. Sometimes that someone is a health department director with expertise in the exact area being misused to harass them. Sometimes it's just a homeowner who's had enough and decides to fight. Either way, accountability matters. Systems of power need oversight. And bullies, whether they're HOA presidents or anyone else, need to learn that their authority has limits. I'd learned that lesson. Patricia had learned it too, though probably not in the way she'd hoped. And Sagebrush Hills HOA had been reformed into an organization that actually served its community rather than the ego of its leadership. Standing on my patio with my wife, a glass of wine in hand and steaks on the grill, I felt satisfied with how everything had turned out. It had been a difficult year, but we'd come through it stronger and more connected to our community. The outdoor kitchen was just a cooking area, but it had become a symbol of something more. The right to use your property peacefully. The importance of facts over accusations. The power of expertise to counter false claims. The necessity of standing up to bullies who abuse authority. Those lessons would stay with me long after the specific details of the HOA conflict faded from memory. And if I ever faced a similar situation in the future, I'd know exactly what to do. Gather the facts, know your rights, document everything, and don't back down when you're in the right. It was a good way to live. and it made the steaks taste even better.